Okay, so let me give you a scenario and how you deal with it. You're a litigant in person, you've been to a court hearing, and when you got a copy of the order, usually a week or two down the line, you find that it's wrong. What it says does not match up with what was agreed or ordered in court. What are your options? I'm Stephen Wade. I'm a Mackenzie friend. I've been helping people represent themselves in the family courts, child matters, finance, and divorce for 17 years now in courts all around the country, including the Royal Courts of Justice. And I'm going to give it to you real what works and what doesn't work, not what should happen. As a litigant in person, not a solicitor, uh, what your options are, how you get around it, how you deal with things, and how you navigate the family court. Okay, so let's get into this. Like I said, you've got an order and the order does not match up what was ordered, what was agreed in court. What are your options? The good news is there's no time limit to deal with this, but you need to get on it as soon as possible, because if you don't, then it's going to look like you were happy with what was ordered on a bit of paper at least, and then you've suddenly changed your mind. It's really important to keep records of what's said in a court arena. It's why I would always advise that you don't go on your own. As a litigant in person, you're going to have to speak for yourself. You're going to have to listen, understand, discuss things, and you're going to need to keep records. If you just turn up at court and you blindly walk away afterwards, and then you think that what was ordered or agreed is different to what's on the piece of paper in front of you, you may have a have a hard time convincing the court that that's the case. And if it favours your ex, then they're probably not going to agree with it. See, as a litigant in person, your ex's solicitor is going to probably be the person that draws up the court order. Back in the old days, when you had a solicitor and your ex had a solicitor, your solicitor would make sure that it made sense and their solicitor would make sense and everything would be good. As a litigant in person, however, things were more tricky. While more court hearings were in person, it was common to get a paper copy of the order before you walked away and you could look at it. And if it wasn't right, you get it sorted out before you actually walk out the building. But now you often won't see that. At most, your ex's solicitor or barrister may email you a copy of the draft order for your agreement, but it's quite common otherwise for you just to get a copy of the order that's been stamped by the court. This is, like I say, this is why you need to make sure you've got your records. You need your notes exactly of what was ordered before you leave the building. So let's imagine you get a copy of the order and it's blatantly wrong. What do you do? Okay, so you need to write to the court, send it to the court manager for the attention of the judge, applying under the slip rule, noting where the order is wrong and what was actually ordered by court. Refer to your notes, be clear about what was agreed or ordered by the court, and ask that the order be amended. Now, it's protocol to send a copy of any correspondence, including things like this, to your ex's solicitor. It's common courtesy. You'd want the same thing. You'd be pretty fed up if you found out that your ex's solicitor was sending stuff to the court behind your back, so you do them the same courtesy. Keep people in the loop. They may well object and say that you've got it wrong, but this is, like I say, where you need to make sure you've got all your notes right. All being good, the court will say, our mistake, you're quite right, and they'll send you an amended order out. That's how it goes. Keep those notes. Make sure you've got someone with you to write those notes, because believe me, you really don't want to be doing this afterwards if you can avoid it.